Right now, Mike Flynn, his case is before the full en banc panel of the D.C. Federal Court of Appeals.
It's interesting here, Andy, and I thought this was really important, that Sidney Powell, and it was a very effective line, said, this is a prosecution without a prosecutor.
We have no prosecutor. The Attorney General of the United States has decided to dismiss this case, but the judge won't do it. So you have a criminal prosecution, and nobody on the other side is the solicitor. Nobody on the other side is the U.S. attorney.
All that they've been talking about is mooted out by the fact that he's even a litigant in this, and there's a rule, and they say they wanted to brief on it, but they haven't brought it up yet, that U.S. Code 28 U.S.C. 455, Dad, which says you're disqualified if you are a party to the proceeding.
In the Supreme Court practice, it's called confession of error. Sometimes a case will go up, and the government, it doesn't happen all the time, but it happens, every couple of sessions. The government will now, after looking at the case, will say, we confess error. We should not have brought this case in the first place. And that is the end of the matter. And then Justice Ginsburg wrote a unanimous opinion for the Supreme Court where she said it's the job of the litigants to frame the issue, not the court.
Judge Sullivan showed bias by appointing an amicus, but Gleason wasn't being chosen as the judge. He was invited to argue one side in an adversary system. An adversary system is so that we get the law right. It's the core of any judge's job to assess cases in view of the strongest arguments that can be made on both sides. And your position is, no, he can't hear both sides on the law. He has to drop the case like a hot potato without adversary briefing an argument. That's your position.
There is no provision for amicus in a criminal case in the federal district court, and certainly not to take the position of the government when it has decided to drop the case. When the government signs off, the case is over. The Article 3 branch cannot make the Article 3 branch prosecute a case.
There is a specific reason that an Article 3 judge is not granted prosecutorial powers like we're discussing here today. Why is that reason? It's because they are not accountable to the American voter like the Article 1 and Article 2 branches are.
Would you agree that still the district court has to make the decision before you can appeal, or before you can seek mandamus, or before you can do anything else?
Well, he's effectively made a decision here. He denied 2 motions opposing any amicus at all and denied our request that the motion to dismiss be granted before he even appointed Mr. Gleason, and then started the whole process that intrudes into the Article 2 executive power that he simply cannot do.
This judge has an attorney right now arguing before an en banc panel of the D.C. Federal Court of Appeals. He is disqualified. So either way, Judge Sullivan shouldn't be the one ruling on the Rule 48 motion. That should be at least the decision, even from these liberals, is that he's got an attorney arguing for him. He's a party. He's disqualified. Those rules govern them.
Let's assume you're right, that there is some discretion to deny the motion. Then what happens?
In this case, it is different from when a prosecution is initiated. If it were denied, there's no role for the executive branch any further because sentencing is the only thing that's left. Now, the government and Mr. Flynn could take the position that they're going to mandamus after that. That's
what a remarkable statement Beth Wilkerson just made.
A defense attorney, too.
A defense attorney who says there would be no role for the prosecutor with regard to a sentencing of the individual defendant who is no longer being prosecuted by the government. This is why, Andy, this is so wrong on so many levels.
When you hear her say that there is no role for the prosecutor to play when a motion to dismiss is denied, okay, that is the ultimate role of the prosecutor to bring criminal charges and nobody else. And I don't know what she's talking about, but for a criminal defense lawyer to utter those remarks is unbelievable to me.
What precisely is the judge's interest in this, any more than there would be in any case where the panel issues an opinion where a district judge may disagree with the Court of Appeals legal analysis?
He doesn't have a right to litigate or is not a party, Your Honor. This court made him a respondent. What that means for purpose of mandamus, I don't think is totally clear, but the court ordered
this
him
court
to
did not order him to respond. He appealed.
To me, it looks like the next stop for this case may well be the Supreme Court of the United States.